First off, we are going to start with liability under Companies Act 2016. Section 266, subsection 1. Every auditor of a company shall report to the members on the financial statements and on the company's accounting and other records relating to those financial statements, and if it is a holding company for which consolidated financial statements are prepared, shall also report to the members on the consolidated financial statements. Next, Section 266, subsection 3. An auditor of a company shall have a duty to form an opinion to each of the following matters. First, whether he has obtained all the information and explanations that he required. Second, whether proper accounting and other records, including registers, have been kept by the company as required by this Act. Third, whether the returns received from branch offices of the company are adequate. And last, whether the procedures and methods used by a holding company or a subsidiary in arriving at the amount taken into any consolidated accounts were appropriate to the circumstances of the consolidation. Now, we proceed to Section 266, subsection 4. An auditor of a company has a right of access at all reasonable times to the accounting and other records, including registers of the company, and is entitled to require from any officer of the company and any auditor of a related company such information and explanations as he desires for the purposes of audit. Section 266, subsection 5. An auditor of a holding company for which consolidated financial statements are required, first, has a right of access at all reasonable times to the accounting and other records, including registers of any subsidiary if necessary, and is entitled to require from any officer or auditor of any subsidiary included in the consolidated financial statements, at the expense of the holding company, such information and explanations in relation to the affairs of such subsidiaries included in the consolidated financial statements. Next, Section 266, subsection 6. The auditor's report shall be attached to or endorsed on the financial statements or consolidated financial statements, and shall, if any member so requires, be read before the company in general meeting, and shall be open for inspection by any member at any reasonable time. Moving on to Section 266, subsection 7. An auditor of a company or his agent authorized by him in writing is entitled to attend any general meeting of the company and to receive all notices of and other communications relating to any general meeting which a member is entitled to receive, and to be heard at any general meeting which he attends on any part of the business of the meeting which concerns the auditor in his capacity as auditor. Last but not least, Section 266, subsection 8. If an auditor, in the course of the performance of his duties as auditor of a company, is satisfied that there has been a breach or non-observance of any of the provisions of this Act. And the circumstances are such that, in his opinion, the matter has not been or will not be adequately dealt with by comment in his report on the financial statements or consolidated financial statements, or by bringing the matter to the notice of the directors of the company, or if the company is a subsidiary of the directors of its holding company, he shall forthwith report the matter in writing to the registrar.
The next part is auditor's liability under common law. There are two parties where auditors have liability. So the first one is auditor's liability towards clients. First one is due to breach of contract. Breach of contract occurs when the contracting parties fail to meet the terms and obligation established in the contract. And the next one is negligence. Negligence can be categorized by two. First, ordinary negligence. It is an absence of reasonable or due care in the conduct of assignment. And the next one is gross negligence. It is a lack of slight diligence or care or omission in reckless disregard of legal duty and consequences to another party. And the last one is fraud. Fraud encompasses a variety of irregularities and illegal acts characterized by intentional deception. When the auditor accepts appointment, he actually enters into a contract with the client, which then indirectly impose certain obligation on him. These obligations may be clearly stated, or in other words, in express term, or unstated, which means it is an implied terms in the contract. This is why the auditor is responsible when he breach of contract, commit negligence and fraud. Besides, auditor also has liability to third party. Third party are like bankers, suppliers, and etc. due to negligence and also fraud. Next, we'll move on to the first case that we are going to discuss. The first case is named Ultramarez versus Touche. It starts with Touche being an auditor of Company A. Company A wants to borrow or obtain a loan from Ultramarez Company, which is the lender. So, before deciding to give the money or not, Ultramarez require an audit report from the auditor or Touche. And then when Touche gave the audit report, Ultramarez decided to give the loan to Company A. However, after giving the loan, Company A went bankrupt. So, in the end, Ultramarez alleged that Touche has been negligent because he failed to detect or report deceptive accounting entries that hide the company's problem. The court held that Touche is not guilty because he is not a party in the contractual privity. In this case, the court held that although Touche was negligent, he is not liable to third party, which is Ultramarez, because Ultramarez was not deemed to be primary beneficiaries. Let's move on to the next part. This is 4 legal principles for third party. So the first one is privity. Privity means a relation between two parties that is recognized by law. For example here, it is a direct relationship in a contract between an auditor and a company. And the related case for this privity is Chandler versus Crane, Christmas & Co. Secondly is near privity. Near privity is also a contract between an auditor and a company, but the one who gets benefit from the contract is the third party. So, in order for the third party to sue the auditor if any matter has occurred, the plaintiff or the third party has to prove that he or she was an intended third party beneficiary. And the third legal principle is foreseen third parties. This is an auditor of Company A. Company B wants to acquire shares from Company A. The auditor knows Company B is going to buy share from the Company A that he is currently auditing. He can foresee that Company B is going to make an investment decision based on his audit report. So he purposely misstate the amount in the financial statement to deceive Company B. Related case for this foreseen third party is JEB Fasteners Limited versus Marks, Bloom & Co. And the last principle is reasonably foreseeable third party. This is where an auditor of a company prepares an audit report for public. Even though the audit report is made for public, the auditor knows that there will be some parties rely on the audit report that he made, even though he does not know any specific person specifically. And lastly, the related case for this issue is Caparo Industries Party Limited versus Dickman and others.
Limited of liability. Limited of liability, according to the Company Act 2006, introduced provisions to enable auditors to limit their liability in respect of statutory audit work by entering into specific agreements with their clients. Liability limitation agreement is defined as agreement that appear to limit the amount of a liability owed to a company by its auditor in respect of any negligence, default, breach of duty, breach of trust occurring in the course of the audit of accounts for which the auditor may be responsible in relation to the company. An agreement cannot cover more than one financial year and must expressly indicate the financial year in relation to which it applies. Now, let's move to the process of how to implement the agreement. As for private companies, the approval by shareholder is through written resolution or at a shareholder meeting. While for the public companies, must hold a general meeting of shareholders to pass a resolution. The process followed by the timing of authorization. First, the Act does not require authorization to be given before the beginning of the financial year to which the liability limitation agreement relates. Second, agreement can be entered into before, during, or after the financial year to which it relates. Third, the timing of authorization must be at the same time as proposing a resolution to appoint the auditors and resolution to fix their remuneration. Lastly, in the case of a public company with only a small number of shareholders, arrangement of liability limitation agreement should be relatively straightforward to be approved by the shareholders at the same time as the company settles the auditor's engagement letter for the financial year. Now, the withdrawal of authorization. Authorization may be withdrawn at any time before the company enters into the agreement. While if the company has already entered into the agreement, It can be withdrawn before the beginning of the financial year to which the agreement relates. And authorization is withdrawn by the company passing an ordinary resolution to that effect. When there is a change of auditor, any prior limitation agreement with the previous auditor will not apply to the new auditor. If the company's incoming auditor wishes the company to agree to limit its liability, the company will need to enter into a new agreement with that auditor. So that's all for limited of liability. Now I will talk about Audit Oversight Board. Audit Oversight Board (AOB) is established under Part 3A of the Securities Commission Act 1993. It is to promote and develop an effective audit oversight framework, and also to promote confidence in quality and reliability of audited financial statements in Malaysia. There are two types of AOB's role. For the first one is monitoring activities. In monitoring activities, the AOB is set up to monitor the external auditor's role, to express opinion on management stewardship related to financial information provided by corporations, and also provide branding to the credibility of financial recognition. For the second one is competency. There are two elements in competency. The first one is technical competency. Technical competency is a technical ability of the auditors in producing their opinions. AOB is mandated to oversee auditors carry their duties of companies' financial information in accordance with the accounting rules and regulations. The second element of competency is professional competency. In these elements, it was found that the respondents associated professional competency with the qualified capability of the auditors as professional auditors. In the respondents' terms, professional competency means maintaining independence. So that's all from AOB role. Elements of quality control. The first elements of quality control is leadership responsibilities for quality. The policies and procedures should be established to promote everyone to appreciate that the quality is essential in every audit engagement. Secondly, ethical requirement. It provides the firm with reasonable assurance that everyone comply with professional ethics, independence, perform job with integrity, and objectivity in discharging responsibilities. The third element is acceptance and continuance of clients' engagements. It provides with reasonable assurance that the likelihood of associations with a client whose management lacks integrity is minimized. It can be achieved by proper scrutiny that of the clients and every engagement. We move to the next element, which is human resources. It is to ensure the process of hiring, assigning personnel for engagement, staff development, and advancement activities that provide reasonable assurance that they have possessed the appropriate characteristics in terms of technical knowledge and training. The fifth element of quality control is engagement performance. It provides the firm with reasonable assurance that the work performed meets applicable professional standards, regulatory, and the firm's standards of quality. Last but not least, the elements of quality control is monitoring. It provides the firm with reasonable assurance that the policies and procedures established for each of elements of quality control are suitable, relevant, and being compared by members. So that's all from us for elements of quality control.
The end.